Okay, so today we'll continue with our lessons on Lego method. So the other time we were treating the introduction to Lego method for year one students that are about to start their journey, their sojourn into the law studies. Now we are also going forward with most of the topics therein. So the other time we looked at the division of law, and we looked at law defined by so many schools of thought. We looked at natural schools of thought. We looked at positive school of thought. We looked at the historical school of thought. We looked at the realist school of thought. We looked at the sociological school of thought. We looked at all these schools of thought. Now, if what I am saying is sounding somehow in your ear, pause this video, go back to the introduction to Lego method, introduction to law that we did, and watch it, then come back to this video. Because all these things are building blocks. It is impossible that you will understand what I'm about to do now without understanding what we have done before. So if this is your first time of meeting me, my name is Chemela Mba, Prof TV. Do well to like, share, subscribe. Please like and subscribe so that it will help circulate these videos to people that need them. Now, today, like I said, we'll be looking at the objectives of law. Objectives of law. What are the things that law wants to achieve? Where does law play very prominent and important role? Now, under the objectives of law, we'll look at it under the following headings. We'll look at law and order. We'll look at law and justice. Under the law and justice, we'll look at the theory of justice. There are so many theories of justice, but we will just limit ourselves, since we are just starting, to formal justice and substantive justice. Then we'll look at law and freedom. And under the law and freedom, we'll look at your freedom of contract. Do you have freedom to enter into any kind of contract? Is there any limitation on your freedom of contract? We also look at political freedom. Are there limitations to your political freedom? We'll look at that. Law and state. We'll look at the meaning of state. Of course, if you are from a very good secondary school, you would have known the definition of state. We'll look at how does law play a role in the administration of a state. We'll look at law and legitimacy. We'll look at how is it that somebody can take up the mantle of leadership in a country. Law and legitimacy. What is the legitimate way someone can become a leader in a country? And is there any other way apart from the legitimate way? And does the law allow it? So we'll look at that. Now, law and sovereignty. We'll look at what sovereignty is and who sovereignty belongs to. Now we'll now look at, finally, law and morality. We'll look at law and morality on a different scale, not really with the objectives of law, but law and morality on its own. So we'll now know whether morality and law are juxtaposable. We'll look at whether morality and law are in pari passu, or in tandem, or in pari materia. So we'll start with law and order. Now, it is very important to note, when you were even in secondary school and they will ask you, why is there law? Why do you think there is law? The first answer you would give is law is there to maintain law and order, to maintain order. Law is there to maintain order so that there will be no chaos, there will be no anarchy. If there is no law, what do you think would have happened? It would be the rule of might and not the rule of right. If there is no law, order would be in oblivion. Order would be an utopia. Order would be something that is wished for, because it would be survival of the fittest. If I enter into a contract with you to deliver me a particular thing, and I've already paid you for it, and you don't deliver that particular thing I said deliver to me, and there is no law that would regulate my next line of action, what do you think would happen? I will try as much as possible to get to you by my own, on my own accord. And by that time, I have taken, that's why you say you have taken laws into your own hands. When you are trying to punish somebody without the instrumentality of the law. And so if that is the order of the day, then there is no order. Because if I am stronger than you, I will always have higher right than you. And if you have something that I want, I will just take it from you and nothing will happen because there is no law regulating us. So order is extremely important. And law is there to ensure that there is order. So that whenever happens and whatever injury you get from somebody, you can use the instrumentality of the law to seek redress, to seek remedy in order for that injury to be well compensated. So that is law and order. It is very important that I bring it to your notice in law and order that Thomas Hobbes stated that life without law would be nasty, brutish, and short. So if there is no law, life will be short, life will be nasty. You will not even like to live here. It's just like what is happening in the animal kingdom. Most of you that watch Nagio Wild would know what I'm talking about. Where somebody can just come out, an animal can just come out and feel like the animal is stronger than another animal and try to eat the animal. Imagine if this is happening in our society as human beings. Would you like to be on this earth? Of course, if you are strong enough, just like the lion. The lion is the king of the jungle. So the lion is enjoying so much popularity and so much leadership because he's almost stronger than most animals. Yes, if you are a very strong person, then that is how you will now like to live in that kind of world. But if you are people like me that we are not strong, we will want law because it's only in law that we are strong. The knowledge of the law. Okay, we look at law and justice. What is justice? Justice is the rightful application of the law. So when the law is applied in a particular situation, then you have gotten justice. Now, it becomes a problem because what is justice to me might not be justice to you. Justice might not be the same for me as it is for you. So we'll now look at all these competing claims that are coming in order for it to go. How do we balance them? Because of course, remember Roscoe Pound's theory about competing claims and competing interests, that law should be made to balance these competing claims and competing interests, that institutions must be at alert in order to balance all these interests. So how do you balance these interests? Is by doing justice. Now, how do you now do this justice? By applying the law. So law is there in order to get justice, because when I say justice is the application of law to a particular situation. If there is no law, how do you now apply the law? If there is no law, you cannot get justice. And so, even though in our adversarial, way of applying law, where there must be a loser and there must be a winner, we have the theory of justice. We have the formal justice and the substantive justice. Now, I'm trying to be so simple so that you will understand this thing one by one. Formal justice is applying the law as it is. When they say if anybody does this, this is what should follow. You should not put your own discretion. The judges in the formal justice are not expected to go outside the law. They are not expected to consider external factors when they are applying the law. The law should be applied as they are. You see, judges will be giving judgment and they say, my hands are tied, which means they cannot go away from that particular thing the law has stated them to do. If you kill somebody, the law is very clear that you must be sentenced after the prosecution must have proven beyond reasonable doubt. The law is very clear that you must be sentenced to death, because that is how it's stated by the law. So you cannot put your own discretion. You cannot even listen to allocutus. So allocutus is where somebody will have to state why the punishment should be mitigated. So that is what formal justice as it is. So are you going to put it like that? Substantive justice is applying the law, but also considering external factors. Not just applying the law as it is, but also using your discretion as a human being. Of course, as a judge, you are a human being. So you're using your own discretion to say, okay, if I apply the law as it is, it might occasion miscarriage of justice, or it might occasion absurdity. It might be so absurd that this law is applied like this. For example, imagine a pregnant woman has been found guilty of murder, and you are saying that you want to sentence the pregnant woman to death immediately. Of course, it will affect the child that is in the stomach that is innocent. The child that is in the stomach that did not even that did not even take part in the crime. So what will the judge do? Formal justice in that particular situation will say, kill the woman. He will say, sentence the woman to death. But substantive justice will say, no, the woman is carrying an innocent baby that has not even taken part in any crime at all in this life. Why not let us not kill the woman like that? Why not let us, mitigate the punishment by sentencing the woman to life imprisonment, so that the woman will at least give birth to her baby and take care of her baby until the baby becomes full adult. That is substantive justice. So law and freedom is another objective. Of course, everybody wants to be free. Everybody loves freedom. Now, most of you are taking your freedom for granted because you have not had anything that would deprive you of your freedom. When you will sleep in cell for only one day, when you come out, you will love your freedom. You would not want to go back to that place again. Because even if, let us even assume that our cells in Nigeria or our prison is a very sweet place, very beautiful place, that there is always power supply, you can watch TV from morning to night, everything you need, okay, let's not say everything you need, is provided for. But the only thing is that you cannot step out of that room. You are only there. At first, you might think it's enjoyment, you'll be enjoying, but when you stay there for a long time, you will know that your freedom is extremely very important. And freedom, man has been fighting for freedom from time past. From time past, man has been fighting for freedom. And it's because of this fighting for freedom, that is why you see that many African countries that were colonized, they fought to get their independence. Nobody wants to be dominated. Even you that you are watching me, most of you are probably still living with your parents. But in your mind, you are waiting for something to click. You are waiting for a particular business you are doing to click well, so that you would not have to be answerable to your parents again, so that you will leave your parents and go and start your own life. And this usually happens to teenagers, especially when they do something bad and their parents admonishes them or disciplines them. What will be running through their mind is that, I will soon go out of this house. And most of you that are even trying to rush back to school, it's still because of this notion called freedom, so that you will be where your parents would not put eyes in your characters and whatever it is you are doing. Freedom. Everybody wants freedom. But is freedom absolute? Or what is now the role of law in freedom? Now, the law provides for your freedom. And most of these freedoms are seen in chapter 4 of the Constitution. In chapter 4 of the Constitution is the part of the Constitution that contains our enforceable fundamental human rights. Of course, I like to call it just fundamental rights, yeah, but let us just continue. Our fundamental human rights. That is, the law have provided for it. Yeah, and also the law also provides for, the formation of pressure groups or unions for you to form it in order to fight for your freedom. For example, trade unions. Trade unions, because of the rising case of employers dominating over their employees and giving them so much harsh conditions to work under. That is why we now see okay, there are trade unions, and these trade unions are there to fight for the rights of their employees or for the employees that are part of the trade union. Now, under freedom, let us just look at freedom of contract. Everybody has the freedom or the right to enter into any kind of contract. But of course, just like our fundamental rights in chapter 4, they are not absolute. Our fundamental rights are not absolute, so also is your freedom to enter into any kind of contract. This means that you cannot just enter into any kinds of contract. The law that gave you that powers to enter into any kind of contract also have the powers to limit your entering into any kind of contract. Just as the law in chapter 4 gave us powers to enter into, gave us our rights, gave us our fundamental rights, in Nigeria, that is enforceable in Nigeria, but also it also made some of the rights have limitations. For example, your right to personal liberty, you have your right to be personally, free, but there are ways that the law can deprive you of that right. For example, if you are caught committing an offense, they can arrest you, and that right will be actually, limited lawfully. Now, freedom of contract, you cannot enter, the limitations of freedom of contract is that you cannot enter into any contract that is criminal in nature. You cannot say that, because I have the freedom to enter into any kind of contract, I will now give you money and will enter into a contract in order for you to assassinate a particular person. If you fail to assassinate that person, I cannot sue you for breach of contract. Because of course, ab initio means from the beginning. Ab initio, I was not even allowed by the law to enter into that kind of contract. Same also with political freedom. You have your right to vote, you have your right to be voted for, but there are still limitations. Of course, the law has limited some kinds of people or some class of people from voting or from vying for election. These are infants, lunatics, bankrupts, etc., etc. Law and state. Now, like I said, if you are from a very good secondary school, you would have known the definition of a state. So I will not bore you with the definition of a state or with the characteristics of a state, where we talk about territorial boundaries, we talk about territory, we talk about laws, we talk about government, we talk about sovereignty, and all these characteristics. But what is now the role of law in states or in the administration of a state? Laws provide for the structure of the governmental powers of the state. If without law, how is it possible that the state would know what kind of system of government they are supposed to follow? Are they supposed to follow the parliamentary system of government, or are they supposed to follow the presidential system of government? Are they supposed to do the federal system of government? Are they supposed to go into the confederal system of government, or are they even supposed to do the unitary system of government? These things would be stated by the law, and the law will guide how their government would be. For example, in Nigeria, we practice the federal system of government, and if you look at section 2, subsection 1 and 2, it's created, or it's stated how, of the constitution, it stated that Nigeria is one indivisible country, yeah? And, it is a federal, shall be known as the Federal Republic of Nigeria, which is broken down into 36 states. So look at section 2, subsection 1, and subsection 2 of the Constitution. Federal Republic of Nigeria, 1999 as amended. I hope you have seen how I've called the Constitution. If you want to quote your Constitution, especially when you are writing exams, you will write it like this. Section, whatever it is you are writing, like now we are looking at section 2. Section 2, you write section 2, what you, section 2, yeah? You don't write subsection. Subsection, no. Subsection is written in bracket. You don't write section 2, subsection, don't mind my bracket, you can do your own normal curve bracket. Subsection 1, Yeah? And subsection 2. That's how you write it. Section 2, bracket 1, and bracket 2. So the bracket is subsection. Now, we have section, we have subsection, and we have paragraphs. So imagine that subsection 2 has paragraph A. You now still put it bracket A. So paragraphs come A, sub-paragraphs come in I. So if you look at this, you can see subsection 2, subsection 1, and subsection 2, paragraph A. Then sub-paragraph I of the Constitution. So please learn how to write this thing. Don't go and be writing section 2, you now write sub-section 1 and no, and you now write paragraph. No. So now we are looking at section 1, subsection 2, section 2, subsection 1, and paragraph 2 of the you now write Constitution. Now I will write it in abbreviation, but you have to write it in full. Constitution, this is how you write it. Constitution, Federal Republic of Nigeria. Constitution, you write it in full, don't write CFR. Constitution, Federal Republic of Nigeria, 1999, as amended. Constitution, Federal Republic of Nigeria, 1999. Don't just write section 2 sub 1 of the Constitution. Which Constitution are you talking about? Constitution, Federal Republic of Nigeria, 1999 as amended. Please, that is how you write it. Now, when you look at section 2, subsection 1 and 2 of the Constitution, Federal Republic of Nigeria, 1999 as amended, you would see what I'm stating, that Nigeria is a federal government. Nigeria is a federal, country, and it is one indivisible country that has its country divided into states. Of course, you know what federal system of government is, where powers are shared between the center and the component units. So it went ahead to divide Nigeria into states, which are the component units. So law and legitimacy. If you also look at section 1, subsection 2, Constitution, Federal Republic of Nigeria, 1999 as amended, section 1, subsection 2, you would see that the law has denied people that are going to take up the mantle of leadership to take it without following the dictates of the Constitution. Which is another way, before you become a leader in this country, there are processes you must follow. And if you do not follow those processes, you cannot be said to be a leader of this country. Read section 1, subsection 2 of the Constitution of the Federal Republic of Nigeria, 1999 as amended. Of course, the section 1, subsection 2 did not list out the processes you should follow, but it's just telling you that you cannot become a leader if you have not followed these processes. That, of course, is listed even in the Constitution and also in the Electoral Act. Law and sovereignty. Law, and again, for law and legitimacy, the law is there to punish you if you try to usurp the powers of the country. Now, usurp means you are trying to take over the power by force. Yeah? So you are trying to plot a coup d'etat. Coup d'etat is forceful taking over of government. If you are being caught, it's a treason, and you might be sentenced to death because it's a capital offense. Law and sovereignty. Now, of course, you know that sovereignty is like the supreme power of a country. Now, the question that the law has finally answered is, where does sovereignty lie? Because if you say the supreme law of the power lies on one person, remember that absolute power, how did they even say it? Absolute power corrupts, absolute power corrupts absolutely. So if you say it is resting on a particular person, why? As in, is there no every tendency for that person to abuse the power? If you say it's resting on a particular group of individuals, won't those group of individuals use those powers to, for their selfish interests? And whoever they want to occupy a particular position would be the ones that will occupy the position. But if you now look at section 14, subsection 2, paragraph A of the Constitution, of course, just look at A and B, paragraph A and B of the Constitution, Federal Republic of Nigeria, 1999 as amended. Now, remember, see, as I'm not saying just Section 14 of the Constitution, so that it will enter your head how you are supposed to be calling it and how you are supposed to be writing it. Section 14, subsection 2, how do you now write it? Section 14, subsection 2, paragraph A of the Constitution, Federal Republic of Nigeria, 1999, as amended. It says sovereignty belongs to the people, which means it's the people that actually have this supreme power. You know what this means? And it means that the government derives their powers from the people. So the people are the leaders. The people are the masters of these people in government. So that is why you would see that lawyers are always trying to hold leaders accountable. Why? Because they understand this, that it is the people that are the masters of these politicians. We sent them there and they are deriving their powers from us. So if they are trying to oppress us, it is as though a servant is trying to oppress the master. Section 14, subsection 2, paragraph A. So we have come to the end of the objectives of law. So now let us look at law and morality. Morality, of course, when we were looking at natural school of thought, we looked at morality and we defined morality as a degree to know what is bad and what is good. How do you know the rightness and wrongness of a particular thing? The standard of values used to measure right from wrong, good and bad. And so most of the times, our communities or groups or social groups or what have you have some morals that they hold so dear. They have some kinds of values that you cannot go against. For example, it would be an aberration, it would be very bad of you that you will see an elderly man in an Igbo community and you will not maybe bow to greet. It would be an aberration in a Yoruba community that you will see an elderly man and you will not prostrate to greet. Respect for elder, morality, but then it becomes a problem because there is something we call relativity of moral. Relativity of moral. So this relativity of moral says that what is moral in my own community might be different from what is moral in your own community. So it is possible that what we hold so high esteem is not what people, in fact, it's all something that people just do. Maybe something we don't like doing in our own side. Maybe, for example, let's say we don't like eating dog meat, but in your community, you like if people eat dog meat every time. So it might be against my morals to eat dog meat, but for you people are very okay eating dog meat. Now, but then there are some general morals that everybody can agree with. For example, murder, stealing. Everybody agrees with these morals. Everybody knows that murder is bad, stealing is bad. However, there are some crimes that people, so sorry, I got a call. So there are some offenses that, of course, everybody agree that it is morally bad. But there are some that people might not, have the same agreement on. For example, when you look at homosexuality, for example, things like abortion, people have different or divergent views on this and whether or not it is moral. Of course, people that support the abortion is, hinge their argument on the fact that a woman should be allowed liberty to do anything she wants to do with her body, while the other people that are against abortion is hinging their opinion or their argument on the fact that it is also supposed to be the same as mother killing a baby that has not been born. The law is now there to balance these interest groups, these interests. Remember those compounds. The law is there now to balance this interest and come up with something that is acceptable. Of course, the people that are supporting this part would have their own pressure groups pressuring the government to accept their own opinion, while the other people, they will be also, so it is now for the law to now pick a side. And of course, like I said here in justice, law and justice, one person must win and the other person must lose because we are having this adversarial or adversarial system. Now, there are some morals that even though you break them or even though you go against them, there are no victims. Yeah, let's say, for example, homosexuality. Yeah, if the two men are doing whatever it is that they are doing, or the two women are doing whatever it is that they are doing, there are no victims that would come and complain to the police that see what happened, even though it maybe it's an offense. Let's even assume that it was made an offense. Because of course, when um, prosecuting a crime starts is by a complainant going to the police to probably complain that see what happened though, then the police will now come and arrest them, they will now start the prosecution. So if this one does not have a victim or somebody that will go to the police, if two men consented and it's not as if one was raped or something, consented and they did what they did and they enjoyed themselves and they left, nobody is going to the police to complain. So in those kinds of cases, the offense would not be if it is a moral, it is a moral, it is something that the people don't like or don't hold in, good morals. The this thing now will now be for you not to publicize that bad morals. So it will now be, bad, or it will now be an offense, sort of, if you now publicize that moral. So see the case of Shaw, please. See the case of Shaw against DPP. See the case of Shaw against DPP. I will not say anything on this thing, but I think Shaw was trying to advertise prostitutes and all that, and he was arrested and charged. So see the case of Shaw against DPP, and you would understand what is it I'm saying about law and morality. So please, this is objectives of law. We've just treated objectives of law, and when next we meet, we will look at types of law. We'll now look at classifications of law. So we are going, we are moving, and I hope you are reading because you have signed up to be reading for the rest of your life. So till I come your way next time, take care of yourself and good luck.